I'm seeking re-election because uh, it's a tough job, but I enjoy it. It's challenging. I think I'm pretty good at it. I think I've proven that over the last 5.5 years, roughly. And it started when I first decided to run for judge. Part of it came as sort of an evolution from the way I saw myself as an attorney, and a lot of focusing on problem solving and resolution of issues. So the next step to being a judge sort of takes advantage of that sensibility, because a lot of what we're trying to do, there's court administration is to provide access to justice, and there's problems there, so we seek solutions. In civil court, you're seeking settlements. You're seeking solutions between parties. And in criminal court, you're trying to see a way to stop recycling of the same people through the criminal justice system. And that is the key question. Well put, because that's exactly the way the situation is. Judges have a certain amount of discretion when it comes to sentencing in many cases. However, since 90% of the cases are a result of plea agreements between the prosecution and the defense, in most of those cases, the court goes along with the plea agreement. It's created an incredible, I use the term algebra for judges, because I always found algebra confusing and difficult because there's so many different factors that come in now. Under realignment, it's changed the whole dynamic. Part of it is very well intentioned, and we have, for example, through the probation department, created a day treatment program for those getting out of prison or who are getting released from jail who are considered high risk. And that's an excellent program. It's intensive supervision. It is day reporting. They're accounted for every day, and they have to go through programs to help address whatever issues it is that causes them to commit crimes, to try to address those directly. It's a best evidence-based practices approach. The problem is for those that don't necessarily fit into that niche, because you have somebody who a year ago you would have said, not qualified for probation, you're going to get 2 years in state prison, because that's, for many felonies, that's the midterm, which is the presumptive term by law that we impose. So if I give a person 2 years in prison, under the realignment statute, they'll actually do 365 days, and they'll get day-for-day credit, so that takes up to 2 years. And they walk out of jail without any supervision. There's no parole, no probation. Yet you take somebody who commits the same offense, but because they're not as bad as that person, on the paper, they qualify for probation. So they're under supervision for at least 3 years or up to 5 years, with search and seizure, testing, monthly supervision fees they have to pay, etc. And so they're under your thumb for 3 to 5 years, where the person who just went to prison has a year and then they're out. So how do you get supervision over the class of people that are considered a little bit higher risk, who you want to be supervised in the community? So you need them to have community supervision. It's kind of like if those people need probation, so that we have supervision on them, that they're subject to search and seizure, at any time, day or night, with or without a warrant, that they're subject to testing for drug use or alcohol use, depending on their terms and conditions. But if they choose prison over probation, we lose that option to a great extent. Certainly the challenge is, well, today, because in my role as PJ, I'm doing a lot of administrative oversight activities. And budget. As the state keeps whacking away at the court's budget, the allowance that we get keeps diminishing. We've lost over $1 million in our budget in the last 4 years. So we have to redesign how we do some things to keep providing services. And the core function of a community court, a county court, is, of course, access to justice for the citizens, whether it's small claims, restraining orders, family law, traffic tickets, unlawful detainers, and of course law enforcement in dealing with criminal filings. But allowing people that opportunity to use the court for what it's meant to, resolve disputes. And the more they cut into the budget, the less able we are to do our core function. But the other part of that is, what's one of the advantages, is the collaborative nature. People work together even from different views. Our collaborative courts, our mediation we started providing in some civil court areas, really make a difference. People get together and are able to work together.